Hi, I'm Charlene Theodore, and I will be your host for this installment of the OBA Foundation video series dealing with bankruptcy and insolvency. Today I'm joined by bankruptcy lawyer Bob Klotz. Thanks for joining us.
No problem.
How does a bankruptcy work?
Well, Charlene, the first thing you have to do is find a trustee. They advertise, so that's not hard. You visit the trustee once, possibly twice, and at that point, the trustee knows enough about your financial situation to advise you whether or not bankruptcy is an appropriate option. If so, the trustee prepares a statement of affairs that sets out all of your assets and your liabilities and a few other questions, and the trustee files it with the government regulator called the Superintendent of Bankruptcy, and that has a few consequences. First of all, it operates to stay all of your debts, that is, to stop them in their tracks, except for a few kinds. One is mortgages. You still have to pay your mortgage. You have to pay your secured debts like a car lease, and you have to pay your child or spousal support if you're separated. So you're bankrupt. The trustee will take all your credit cards from you, at least all the ones that money's owed on, and will cut them up with a pair of scissors so you can't use them. The trustee gives you a couple of counseling sessions during the course of your bankruptcy to give you some financial literacy if you need it. Then, of course, there's the question whether you have to tell your employer.
Do you have to tell your employer?
Well, only if your employer is a creditor. Otherwise, the employer never needs to know. So that's nice. There's a certain degree of confidentiality there. Now, another consequence is that all of your property vests in the trustee in bankruptcy. That means any real estate you own, any savings, investments, and so on. There are lots of exceptions, though. For example, your car, at least about $6,000 worth of your car is exempt. Your tools of the trade, if you're using them, are exempt up to about $11,000, and your household goods are generally exempt. And this, of course, applies to resale value, not the original purchase price. If you have a pension, that's exempt. If you have an RRSP, Registered Retirement Savings Plan, that's also exempt, except for 1 year's contribution before the date of bankruptcy. Finally, your income is exempt if it's low, but if it's beyond the poverty line, then you have to pay roughly half of the surplus. That's called surplus income, and it's paid either for 9 months or 21 months, depending on the length of your bankruptcy.
So how does a bankruptcy actually work?
Well, when you're in bankruptcy, your debts are stopped, except for the ones that I've mentioned. While you're bankrupt, you have to disclose your bankruptcy to anyone that you borrow money from, over $1,000, or with whom you enter into a business transaction if you're self-employed. You stay in bankruptcy for either 9 months or 21 months if this is your first bankruptcy. It's 9 months if you earn less than the poverty line, and it's 21 months if you earn more than the poverty line at any point in the bankruptcy, so you have to make those surplus income payments. Finally, there's what I call an exit fee. That's the discharge in bankruptcy. You're discharged automatically after the 9 or the 21 months unless either the trustee or a creditor opposes your discharge. For example, if there's a creditor that thinks you're a bad person or who thinks you've abused credit or some other reason, then they will oppose your discharge, and you have a hearing before a bankruptcy registrar to determine whether your conduct was honest or whether you should be subject to a conditional discharge order, which I call an exit fee. And that can go on for a number of years if you've done wrong or if you've tried to defeat your creditors in an improper fashion.
So my next question for you is, what is a consumer proposal and how exactly does it work?
Right. Well, it's an alternative to bankruptcy. It's a way of avoiding bankruptcy while also arranging to pay out your creditors for less than they're owed. For starters, a consumer is someone that owes up to $250,000 to the creditors, and that doesn't include any mortgage on the family home. If you owe under $250,000, then you can file a consumer proposal. Otherwise, you have to file a more complicated version called a commercial proposal. So as with the bankruptcy, you start by finding a trustee. And the trustee for a consumer proposal is called an administrator, but I just call them trustees just for convenience. And the administrator helps you figure out what you have to offer your creditors so that they might accept your consumer proposal. You can pay that out over 5 years. The idea is, if it's more convenient to you to file a proposal, keep your assets, and pay over time, then you can avoid bankruptcy. And that's an objective of the legislation, to try and avoid bankruptcy if it's possible. So you sign that proposal, that offer, it's mailed out by the trustee, and any creditor who doesn't respond is deemed to vote for the proposal. So there's a default yes vote. The creditor's claims are stayed, the same as in a bankruptcy, with a couple of additions. First of all, your landlord can't evict you for your rent arrears up to the date that proposal's filed. You have to keep the rent in good standing, but you can't be evicted for those prior arrears, so eviction is stopped. Same with utility disconnection. Hydro can't disconnect your hydro based on your existing arrears. Ultimately, there's a vote of creditors, and you need half of the creditors who are voting. In consumer proposals, that's very, very common if the proposal is designed properly by a trustee who has a sense of what the creditors do. And the trustees really do have that sense. They know what the income tax department likes to see. They know what the credit card companies insist on seeing, and they can help you fix that amount. And finally, if the consumer proposal is defeated, there are no real consequences whatsoever, except that you can't file another proposal for another 6 months or so.
So if I own a home, do I continue to own my home if I declare bankruptcy?
Well, okay, let me divide that into two parts. If you file a proposal, you continue to own everything. You don't give up any of your assets. Bankruptcy is different. You do lose your assets. So if you have an interest in the home, that becomes the trustee's property. Now, there are two questions. What if there's no equity in the home? Well, in that case, you can arrange to buy it back from your trustee for probably zero at the end of the bankruptcy. In fact, the trustee might not even take possession or take ownership of the home at all. If there is some equity and it's over $10,000, then the trustee can ultimately either sell that back to you for the amount of the equity or sell the property unless there are children in the home and it would cause some hardship, in which case it would have to wait. So really, if you discuss that with the trustee, they're very familiar with how to deal with the home, and they'll tell you what your options are and work out the best option.
But what if there is equity of $10,000 or more? What happens then?
All right. Well, the trustee will give you the directions, but here's what the trustee will say. First, the trustee will tell you to get an appraisal from a real estate agent. Figure out how much your share is worth, and that'll depend on what the appraisal is, whether you own all of the home or half of the home, and how much any mortgages are. Then the trustee will present the options, and those are you can buy your share of the house back from the trustee over the course of the bankruptcy or afterwards. You can make arrangements to pay the trustee over time. Your spouse or a family member can buy your interest of the home, or you can let the trustee sell the home. Now, if you can't afford to buy the home from the trustee will be entitled to sell, and you'll have to leave. The exception is if the house is jointly owned, and it would cause hardship to the kids or to your spouse. In that case, the sale is postponed, and that's something that's determined by a court.
So why would someone want to consult a bankruptcy lawyer?
Well, lawyers are good if there are complications that occur or that are likely to occur in a bankruptcy. For example, if you're engaged in matrimonial litigation or you've separated, then there are complexities when the two areas intersect, and you'll want a lawyer to help you through some of those or to avoid any problems arising. If you have one motivated creditor, for example, if there's only one creditor in the bankruptcy or one big creditor, then you can expect that creditor will cause you difficulty in the bankruptcy. You might want to get a lawyer involved, for example, at a discharge hearing. If you're already involved in a lawsuit with someone that claims to be owed money, or frankly, if you are involved in a lawsuit where you're suing someone else for money, you might want advice about that because there can be complications. And finally, if there are criminal charges involved or fraud is alleged and there's a threat of criminal proceedings, you might want to get advice, if only from a criminal lawyer, before you start a bankruptcy to make sure that this step won't hurt you in some manner.
Any other reasons why someone would want to consult a bankruptcy lawyer?
Well, some people want advice about whether they can transfer their assets to a spouse or to someone else before bankruptcy. There are real problems with that, but people do want advice about it. If someone owes you money and has declared bankruptcy or filed a proposal, you want to get advice about that. A trustee can give advice, but it is legal, and you might want a lawyer. If you are bankrupt and you're having problems with your trustee, you don't believe that the process is being handled fairly by the trustee or by an administrator, there is a complaints process to the superintendent of bankruptcy, but often people want to get legal advice to deal with that problem. Those are some of the reasons you might want a lawyer.
Can you explain what the difference is between a lawyer and a bankruptcy trustee?
Right, this is actually a common question. Trustees are not lawyers, although in Canada there are about 6 of them who had legal training and became lawyers, but they don't currently act as lawyers. Mostly they're trained accountants. They know much about the law of bankruptcy. They have to do their job, but they can't give legal advice. They can go to court and they can make statements to the judge like lawyers do, but the judges know that they are not lawyers. They have to study for about 5 or 6 years and pass through a rigorous testing process to become a trustee. They're regulated by the federal government through the superintendent of bankruptcy. They have a code of ethics. They have a formal complaints process. They're responsible to a whole bunch of interests. They're responsible to the bankrupt person, to the creditors, to the court, and to the regulator. So they become experts at handling conflicts of interest, not avoiding them, but handling them. And one other difference with lawyers is there is no confidentiality between you and your trustee. If you tell them, I did it, or I have an asset in the Bahamas, then they do not have to keep that confidential, quite the contrary. Now, lawyers are different. They go to law school and they're trained to give legal advice. Unlike trustees, they are responsible and they're loyal only to their client. There's a duty of confidentiality that lawyers have for anything that's communicated between the lawyer and the client, unless, of course, the client threatens to do something criminal, in which case the lawyers have to notify the police, so they won't. While lawyers can be unfamiliar with the practical side of bankruptcies and proposals, they're generally more knowledgeable about the law than trustees.
If someone wants to declare bankruptcy or file a consumer proposal or just simply wants advice about these types of issues, should they consult a lawyer or a trustee in bankruptcy?
Well, all right. First thing to know is that most trustees give a free 30-minute consultation. When something's free, I highly recommend it, at least for starters. So that's certainly worth a try. If you want to get confidential advice that can't be used against you, you go to a lawyer, no question. If you know that your issues are complex and you want to pay for good legal advice, then you see a lawyer. Most people actually are not sure about that. Now, there are good and bad trustees, just like there are good and bad lawyers. A bad trustee will advise you to declare bankruptcy without doing a full analysis of your circumstances. A bad lawyer will charge you for advice that a trustee would give for free. So good lawyers and good trustees will tell you whether you need one or the other. How do you know if a trustee or a lawyer is good or bad? That's a really good question that I can't possibly go into in this video. Now, it's a question that's worth asking to any lawyer you consider hiring or any trustee whom you consult. Do I need to see a lawyer first, or should I see a trustee first? And ask it to the other side, and they should be able to tell you.
That's good advice. How much does it actually cost to file a bankruptcy or a consumer proposal?
Right. Well, starting with bankruptcies, the fee is paid out of the assets. And if there are no assets that can be sold and so on, out of the monthly payments or the surplus income. And if there are no monthly payments or surplus income, then through an upfront payment. The cost can vary depending on how much the trustee has to do, but it usually starts at about $1,700 or $1,800 in urban Ontario. And this is something, as with any professional, that you should discuss with the trustee ahead of time. Consumer proposals, there's a sliding scale. It's a percentage, and it's fixed by regulation. It's also paid out of the proposal payments. Again, you ask the trustee.
What kind of debts are not extinguished by a bankruptcy or a consumer proposal?
Well, there's a list of them in the legislation. Assault damages or sexual assault damages, they survive. Child and spousal support and alimony survives. Breach of trust or debts incurred through fraud or misrepresentation, that's lying, they survive. Student loans survive if the bankruptcy is filed within 7 years of ceasing to be a student. And that's actually not 7 years from the date classes end, but 7 dates from, I think, the end of the month when graduation occurs. And there can be a mercy hearing to wipe out the debt, but that hearing can only take place after 5 years, and it's subject to judicial discretion. And finally, if you incur a debt after you filed the bankruptcy or the proposal, then that won't be caught by the bankruptcy. It will survive. It can be enforced even during the bankruptcy.
Is there anything one should do before declaring a bankruptcy or filing a consumer proposal?
Yes. if you're going to consult a lawyer, do that first rather than after filing your bankruptcy or your proposal. It may be too late to give good advice then. Now, after you file, your credit rating is going to be hit hard. It will be lousy for about 5 or 6 years after you file the proposal or the bankruptcy. So you might want to consider and discuss with the trustee whether you should lease a car before filing your bankruptcy, whether you should renew your mortgage before filing, whether you should find your new apartment before filing your bankruptcy, because that can be difficult if a prospective landlord or financier wants to look at your credit rating to decide whether to accept you as a tenant or as a lessee. The second thing is you should try to settle with your creditors, or at least your largest ones, before going the bankruptcy or proposal route, because it is easier to get out of bankruptcy, for instance, if you've tried to negotiate with your creditors. So that's worth doing. And also your trustee will discuss that with you.
That's great advice. Thanks so much for coming.
Oh, you're very welcome, Charlene. By the way, I'm told that you've been elected as Lawyer of the Year for the Ontario Bar Association, so I wanted to extend my congratulations to you.
Thank you. I sent out a Skywriter plane, so I'm glad you saw that.
Thanks.
You're welcome.